Good afternoon.
Good afternoon, Judge. Nice to see you. Thanks for coming over.
Thank you for the invite.
We just met outside, but again, my name is Mike Sasso, and the way we're going to proceed is that each of the commissioners will introduce themselves. We have one commissioner, Commissioner Carl. She's attending my phone, and then after we do that, you'll have 2, 3, 4 minutes to make an opening statement. I'll have about 20 minutes of Q&A, and then I'm the timekeeper. I'll stop that, and we'll give you a couple, 3 minutes to make any closing remarks. So we'll get started.
Afternoon, Your Honor. Vincent Citro, the law offices of Horowitz and Citro.
Greg Dyer, 7th Circuit Public Defender.
Andy Bardos, Craig Robinson.
You're Mike Sasso, Sasso and Sasso. We have Commissioner Amanda Perry Carl on the speakerphone. Remote.
Brett Renton with Shetson Bowen in Orlando.
Good afternoon, Your Honor. Petra Brownlee, the Brownlee Law Firm.
Hi, I'm David DeArmas of Kramer, Price and DeArmas.
Your Honor, Scott Thomas with Byrne Foreman.
And thank you. My name is Mike Murphy. I'm, as you know from the paperwork I filled out, I'm a circuit judge in the 9th Judicial Circuit. Prior to the division I'm in now, I've served in the circuit criminal division, the domestic violence division, the general and family division. And for the past 20 months, I've been in the general civil division, which in Osceola County, one judge and myself, we do civil, mental health, probate, and guardianship. In fact, my favorite part about the current division I'm in is I do the Marchman Act, well, along with Judge Schreiber. And what I really like about that division is you get to root for the person on the other side, the only time you can, because you're taking them from an addiction, hopefully get them to a point of through treatment, get to the point where they're able to make decisions on their own. When I tell my friends that that's my favorite part there, they're kind of surprised because I'm not known as a warm and fuzzy person. I'm usually considered a patient but unemotional. In fact, when people appeared before me in family law, they'd always like to say, hey, Judge, this is a court of equity, and my favorite response was, well, it's only a court of equity when the law allows it to be a court of equity, otherwise it's just a court of law. So growing up, I didn't always want to be a lawyer. I watched Perry Mason, People's Court, but I never wanted to be a lawyer, never wanted to be a judge. In fact, I wanted to be a city manager. And after I got my business degree and was looking for what was I going to do next, my mom said, hey, if you want to be a city manager, why don't you become a lawyer first? It couldn't hurt. I really wanted to get a master's in public administration, but to appease her, I spoke to in South Florida where my father worked for a city. I talked to the city manager there and the mayor and the commissioners. And the city manager said, got to get the master's. The mayor commissioner said, got to get the law degree so you're one up over the lawyers. I figured since the mayor and city commissioners are the person or people that appoint the city manager, I must go to law school. So I went to law school. At first, a little difficulty in law school because I'm a numbers person. I like that 2 + 2 is always 4. As you learn from law really quickly, nothing is ever as clear cut as 2 + 2 = 4. So by the second semester, I realized I really like logic, and law is a lot about logic. So then I started to really love law. Then in practice, I realized there's a slight problem, and that is that there's a human component, the judge. And I'm sure we've all been in front of judges who, even if you give a case that's on all fours, there are some judges who might have already had their mind made up. We're going to find a way to distinguish that case even if the opposing counsel didn't even argue a distinguishing factor. So after law, I figured, I could do that job better than some of the people. There's definitely some fine judges, but I thought, might as well try. So I ran and got elected. And I go by the name Mike Murphy instead of Michael Murphy, and people sometimes ask me why, and it's because when I ran as Mike Murphy. And I was never a fan of judges who, for example, ran as, say, Jim Henson, but on the bench he was James E. Henson. I figured if you run, you're kind of married to the name that you run with. So that's why Mike Murphy instead of Michael Murphy. Right now I have what I'll call a dream job for me. A lot of other people would think a circuit court spot, circuit judge spot is a dream job. And I agree it is, but I'm now looking for something more. Where I can go in-depth legal research on complex areas of the law with the time to thoroughly review it, and the added component of having to try to convince someone else on a 3-judge panel that I'm correct, or let them convince me that they're correct. So I'm here to answer some questions, and whenever you're ready.
I was one selected to vet you and to inquire, and so the way we've set things up, I do the initial questioning. And the first question is kind of a broad one, but it's a good one for, I think, to get some idea of where you're coming from. That's to get your judicial philosophy And where does an appellate judge fit into the overall hierarchy of how we get the laws that we have?
I would get the laws, and we get the laws through the legislature.
However you want to
I
answer it.
understand. Obviously, we get
Up to
the
you to
laws,
answer it.
got it. We get the laws through the legislature, we have separation of powers. It's for courts to interpret the law, but we're not here to create the law. Some people are tempted, if given an opportunity to appellate court judge, you have the ability to write opinions that have the effect of law, but that's not what we're supposed to do. We're supposed to interpret the law. There's a presumption of constitutionality of the laws. We interpret laws in harmony with the other statutes, and it's just not, it's not an opportunity for people with agendas to change the law. That's what the legislature is for. So that's my judicial philosophy, is to follow law, hold judges in the trial court accountable for following the law as well.
That's true at every level
Is it?
of the courts?
Well, it should be. Of course, when the Florida Supreme Court, if they if they accept jurisdiction over a case, they have the ability to address issues that weren't even raised by the parties below. Appellate courts are limited to what was raised below, and so there's a difference.
I saw, and this is just sort of an aside because I happen to speak fluent Spanish, that one of your hobbies was learning Spanish. Tell us a little more about that.
Yeah, on day 401 of Duolingo. In fact, I was doing it before I came in here because I hadn't done it for today. It doesn't mean that I know enough to be fluent. In fact, I know enough just to be dangerous. For example, when I was in Madrid last October, I meant to say goodbye to the person I was in the elevator with, which was, or I'll see you later, nos vamos, but I said nos vemos, which means come with me. So at first,
Actually, you got it backwards that time.
oh, did all right. So I'm never going to get past that one.
I'm gonna review that one.
Right, just enough to be dangerous. So. Right.
Now that person lives with you.
No, I gave it a funny look. And I understood why after I talked to a friend of mine. So nos vemos, see you later, nos vamos, come with me. Got it.
And then in question 14, and we talked about this a little bit before, but I think it's worth exploring again, asked about the controlled substances and the situation before. Just tell us a little more about what happened and, you know,
Why is
how you
it
point it, why is it here, and what your view is generally on how that should affect what we're doing here today.
All right, well, how did it happen? It was a voluntary decision.
Right.
Got it.
Everything you
Voluntary
want to
decision
do.
on my
I'm
part.
giving you open-ended questions. You answer
I
whatever you want.
appreciate it. Voluntary decision on my part in states that allowed it to happen. I included it on here because some people would say, under federal law, it doesn't matter what the states say. So I'm going to err on the side of caution of disclosing it, because in fact, if it is a violation of federal law, then there you go. And if it's not a violation of federal law, at least you all know. Obviously, I could have not answered the question. My principles mean more to me than success. So if ultimately it's held against me, it's held against me. It's something for you all to decide. But I put on there because the answer is a truthful answer.
And then the final thing I would like to just ask you about, that's unfortunately the first question, I get to ask them the tough questions.
It's fair enough.
Question 48E is asking about pro bono legal work. And the response is, I do not recall any significant pro bono legal work before becoming a judge.
Right.
I think that's worth elaborating on a little bit, if you can do that for us.
Well, it means I don't recall. I became a judge in 2000. I was elected in 2004. I can't remember doing anything other than the minimum when I was in the Orange County Bar Association would have allowed me, which would either volunteer for 3 cases or pay $300. I can't recall anything other than maybe something like that. As a judge, I would make myself available to voluntary bars to be there to assist them with events. But that would be probably the extent of the pro bono services.
So when you were a lawyer, did you pay the money, or did you do GAL or other type of work? Or
I
just don't
remember
recall?
well, I can't, everything I'm saying here, I have to believe it have to be true, and I cannot recall specifically. I do recall being guardian on criminal cases. I cannot recall specifically if that was because I was working with other people also, because remember, I thought guardians on criminal cases were the best way to go, because the guardians on criminal cases, the cases don't last for 20 years. If you're a guardian in a domestic case, you might be with that child for a long time.
Okay. Those are the questions that I had, and I turn it forward to others.
What year again, Judge, did you become a judge? I know it's in there, I just
Thank you.
forget.
I ran in 2004, so I started in January 2005.
Your Honor, you made an interesting comment earlier about working with others. I mean, certainly in your courtroom, it's your courtroom. And you would be looking at least a minimum of 3-judge panel, most times.
Right.
And I noticed the Phillips case, which is in here, was one you sat as associate judge, and you actually drew both a concurrence and a concurrence with an opinion from Berger and Lawson. I can't get into, I don't want you to get the details out, so you can't, but I'm curious as to, in terms of that collegial relationship, what are the interests that would make someone write a concurrence as opposed to it's not a whole panel decision, or would make you feel like a dissent's warranted? What are the kinds of interests that are properly advanced with that additional opinion writing?
Well, what's advanced is you get at the time of the opinion the opportunity to hear from other judges who you can bounce things off of to ultimately arrive at a conclusion. In every case, I want to make the correct legal decision. And when you're in court and you're making decisions as you go, obviously you believe you're making the correct legal decision at the time. But to have the time to research it, bounce it off with other judges before rendering an opinion, it's worth more to me to be correct than it is to be fast. And so that's why I would happily participate in a panel as opposed to just making decisions by myself.
But I guess what I'm really trying to get at is why you bounce that off. And so at a certain point, I suppose, I have no idea, I'm just a practitioner, that someone says, I hear what you're saying, but that doesn't work into my majority opinion. You need to write that separately. What are the scenarios that creates that? Why can't things be adopted? What's the need for concurrences?
Well, sometimes one of the judges wants something extra to be in the majority that the other 2 people don't, that they were not able to convince the 2 people in the majority to include, and that's why you write a special concurrent opinion. Or perhaps it's just someone wants to do, 2 people are okay with a PCA, and someone wants to do a concurrent opinion to explain something about the case so that other people know what it's about.
Do you think how valuable do you think that is to explain to the litigants, why exactly the court would rule the way that it did?
I'm not a fan of PCAs wasn't as a lawyer, not as a judge, and it wouldn't be as on the DCA. For a couple of reasons. The practical for lawyers, lawyers usually paid some money by a client. The lawyers probably told the client, they think there's a good chance, or at least a chance of success, and when you get a PCA, it's kind of hard to explain that to a client, what exactly happened. The client might say, how do we know they didn't make a mistake or whatnot, even if they hadn't made a mistake. As a judge, it's nice to be told why you're right. A simple PCA, I'd like to say, creates a hidden body of law. How many times is someone given a circuit court opinion and attached to it the PCA from the DCA? Well, what does the PCA mean? No one has a clue what it means. There's lots of reasons why the court could have PCA'd the case that has nothing to do with the fact that the analysis done by the trial court was correct. I think there's nothing wrong with a DCA opinion that comes out and says the court reviewed the following 3 issues. We applied this standard to this standard, there's competent substantial evidence for this, or whatnot, and then just author an opinion, even if it's not that long of an opinion. So hopefully that answers your question.
We've heard today that, and of course it's true for jurisdictional purposes with Florida's district courts of appeal being courts of last resort, once an opinion, not a citation PCA of course, but once even a small paragraph is written, it opens the doors for Supreme Court jurisdiction. Suddenly there might be a little fodder for a petition for writ of certiorari. So do you think that should play a role in the district court judge's decision on whether to write?
Absolutely not. For a couple of reasons. One, that it sounds like what you're saying is there's going to be an extra $300 filing fee in each one of these cases, so suddenly there's going to be more money coming into the state. That's not a problem. And so doesn't mean the Supreme Court has to accept jurisdiction. So just because that happens doesn't mean you're going to get the Supreme Court issuing a whole bunch of opinions. So there's nothing wrong. In fact, what's wrong with a Supreme Court telling the DCA they were wrong? What is that the worst case scenario?
So let's just say somebody was to pull the report on you as you've served as a judge and all of the appeals that have been taken, the orders that you've issued, and those that have been reversed, right? What do you believe, right, should be the takeaway if somebody's looking at those particular remands or reversals?
You mean, does reversals indicate a specific
I-
type of judge?
I mean, I can, not asking that in general, asking to you, because you get all of the cases that you're either affirmed, and majority of your opinions are all affirmed, right?
Right.
But there's times when you get reversals,
Right.
and they're sent down with explanations, and so I'll jump to my follow-up, which is, are there any cases that stick out to you, lessons learned, issues that came up, things that you've taken? Or are there cases that you just simply disagree? You think the DCA got it wrong, they've sent it back to you, but your underlying order, you believe was pretty clear? Or are there cases that jump out even more, because those were then appealed up, and the Supreme Court came out on your side?
I think the natural reaction when you're reversed is kind of like ouch. Sometimes they're delivered in a way that has the ouch effect, I'll say. And then sometimes it's like, for example, I was recently reversed, and it was the gentlest reversal I've ever had. They certified the question to the Florida Supreme Court. It was about, on a motion for summary judgment, on one side you had an affidavit saying the accident occurred X, a video camera showing, I think my opinion was 180-degree opposite, that it couldn't possibly be what this affidavit said. And I relied upon a U.S. Supreme Court case and a Florida Supreme Court case, and I granted the summary judgment. The Fifth TCA said, well, under our standard, you're required to have denied, no matter how ridiculous, I don't think they used the word ridiculous, but it was close.
You're pretty close to that.
Yeah. So they certify that to the Florida Supreme Court. I hope the Florida Supreme Court takes jurisdiction. So that's one of those where you get reversed, you're like, oh, that's not bad at all. I had a case early on in 2011 where I said, we applied the plain meaning of the statute, applying the plain, it was a Macchione case, electronic threats. Right? And I said, this statute that was written in 1913, it's communications. It doesn't matter that there was electronic communications back in 1913, they're called telegraphs, telegrams. Therefore, the fact that the legislature later on includes specifically electronic communications doesn't mean it wasn't already included in the statute before. The Fifth TCA reversed and said, basically what I did was render the addition of language of electronic emails or electronic communication meaningless, and the legislature doesn't do meaningless stuff. So it turned into an ex post facto law. And follow the law. Did I agree with that? I follow the law. So I think the only way to really take from the reversals versus the affirmances is to actually look at the underlying opinion. It's true. Sometimes I've learned that I need to be more factually specific in my orders and not to assume anything. Probably the same thing lawyers should do when they argue stuff in front of judges, not assume anything.
Can I ask you about the Lyles case?
Yes, sir.
Which was one of the writing samples that you submitted. You held that a statute is unconstitutional, and you wrote that by failing to include an exigency requirement in the statute, the legislature fully abandoned its responsibility to enact constitutional laws. Can you tell us about that, the case, what the issues were, and why you found that to be unconstitutional?
So what happened is the legislature interpreted Schmerber from the U.S. Supreme Court with regard to blood draws on a DUI case, and they created the statute. They later, in 2002, instead of making it implied, like an implied consent involved in an accident, they said, law enforcement officer shall take the blood sample. Or before you used to say, before 2002, we used to say, by driving on the road, you've impliedly consented to giving your blood under the following circumstances. Well, McNeely came out and said that there's no, you basically need to get a warrant. So what I wrote in that Lyles case was, by changing the statute and requiring the law enforcement officer to take the blood, without no longer finding of it included in implied consent, that would be the legislature abandoning its role, because you still needed a warrant, even under Schmerber, even under McNeely. Now, ultimately, the Fifth TCA, when they reversed the Lyles case, they just said that the blood draw statute is just included in implied consent. They did not specifically reference the amendment in 2002, which changed it from specific implied consent to a direction to a law enforcement officer to do something. And so that's why I said they abandoned their role. The abandon their role was based upon how to apply the good faith exception to the search warrant requirement.
Are there other courts that have examined the same statute? you know?
I know that the fifth did, and then I think the fourth recently did also, and I think they're equivalent to what the fifth said.
Anybody else have a question for the judge? All right, well, thank you, Judge. That will conclude the Q&A portion, and this is your opportunity to make any remarks you'd like to make to the commission.
Thank you. Thank you for allowing me to appear before you all. I know there's no requirement that you all interview every person who applied. And thank you very much for what you do in volunteering to make our judicial branch the best judicial branch that can be. I mean, obviously, I hope that you put me through to the next level, but if the process ends for me here today, know that I'm still going to go back to the Ninth Circuit and well and faithfully perform my job there with honor. Thank you all very much.
Thank you, Vice Chair.